I have a question for His Excellency, which really is whether it is his view that the Caribbean states are likely to find themselves before that court either as victims or accused at any time, having regard to the provisions of the treaty, of course.
I have not seen the evidence to support the view that they might be or should be brought before the court. They have been, what I would say about the Caribbean states is that the interest that was shown in the beginning by CARICOM seems to have waned, and that is most unfortunate, because CARICOM should have been seen always as having been playing and as having played a leading role, as indeed CARICOM did play. The matter could not have gone to the United Nations General Assembly without the support of CARICOM. It was CARICOM support that enabled it to be taken to the General Assembly of the United Nations. And since then, CARICOM has had a very low profile, very unfortunately in my view, for the people of CARICOM.
Thank you very much. Are there any questions? Yes, there's one here. Thank you.
Good afternoon. This is a question directed at His Excellency, Mr. Robinson. I found Mr. Pollard's comment on the apparent, perhaps lack of independence. I don't know if that's the right word I'm using, Mr. Pollard. The concerns expressed by Mr. Pollard about the neutrality then of the court. I wondered what are Mr. Robinson's views on that comment. If you could share your reaction to that comment with us, Mr. Robinson, I'd be very interested.
May I say that there has been no thought or belief among those of us who conceptualized the court that it could produce a perfect system of justice. And in fact, concessions had to be made. Concessions which would, in my view, fall short of the concept of justice in order to involve sufficient states in the process. You know, in the beginning, none of the larger states supported the court. It was only CARICOM and two other non-CARICOM states that supported the idea of the court. And as we progressed, we happened to have more support from countries like Canada and so on, larger countries. But this was only over a process of time. My own belief is that the larger states, including, let us say, the United States, will support the court. I happen to have been sitting with a member of the State Department by my side at one of these meetings, and being aware of the fact that I myself was being catapulted, as it were, into a leadership position, I turned to him and I asked, why doesn't the United States support the court? You know what he said to me? Well, you see, if we play a more prominent role, it will be said that we want to control the court. So we prefer a smaller state to promote the idea rather than we do it. Well, not a satisfactory answer to me, but that's what he said.
Is there any other question from the floor? Your Excellency, did America initiate the move to add drugs and crime as drugs rather as one of the other crimes which the court may look at? I had the impression that it wasn't initially meant to be included amongst the catalogue of crimes.
Well, for one thing, aggression was always within the contemplation of the United Nations system as one of the crimes which should not be condoned internationally. But the problem was trying to find a sort of a definition of aggression which could be generally accepted. And as you know, in the words of Professor H.L.A. Hart, a definition is primarily concerned with an enhanced awareness of words to sharpen the perception of phenomena. And the people who were involved in trying to define this term aggression could not agree. Because the Eastern European states were saying, you know, aggression comes from the Roman term aggredior, aggredi, aggressor sum. He who makes the first step must be deemed to be the aggressor. And the Western states, headed by the United States, will say, no, the question of animus is determinative. Unless you could establish animus, there can be no aggression. And the two sides simply could not meet that. I see the judge got a resolution, which apparently bears more on the principle of he who attacks first must be deemed to be the aggressor. But that's one issue which they could not really solve.
Probably there's one? Yeah. Sure.
When the court started and when we were in Rome dealing with this, the original idea was to have drugs, and Trinidad and Tobago was extremely strong on recommending drugs. But then you had countries in Asia demanding that terrorism be included. But then that caused another problem as to definitions. And in as much as there are several definitions of aggression out there, because the United Nations have defined aggression in several areas. You have the Resolution 1314. There are several definitions of aggression existing, but the one that would have to be acceptable for the International Court has proven problematic, and the working group has been meeting on this for the longest while. And in fact, there is another meeting of the working group on the crime of aggression that's going to meet in Columbia University next week, still trying to hammer out a solution, and it is hoped that some resolution will go forward at least to the review conference in Uganda in 2010. So there is work being done, and that it is for that reason that it was put in the, I think it's Article 124 or 120, whichever it is, that at the review conference coming up in 2010 in Uganda, the court will have to look at this business of whether to include drugs, terrorism, and aggression. But terrorism is as far as you can ever get, because at the UN, even after 9/11, you couldn't have a definition of terrorism. So that is dead, practically. And they're still trying with aggression and drug trafficking. The problem with drug trafficking has been it is felt that it should more be dealt with in the municipal courts. And so there may not be very broad spread support, much less consensus for it. So even drug trafficking at the review conference is hardly likely to be included. But we'll wait and see what happens in 2010 in Uganda.
Thank you. The other question in that area.